Madam Speaker, I stand up and, I move that the Public Inquiries Bill number 5 of 2025 be read a second time, and I stand as Acting Attorney General in this matter. Madam Speaker, the Public Inquiries Bill is not a routine update or a cosmetic change of name, the same old product in a new packaging. This is a reform of our whole approach to administrative inquiries, a reform whose time has come and whose necessity is both practical and historical. For this bill is about how the state confronts the truth, how it learns from experience, and how it responds when something has gone wrong or is feared to have gone wrong. As honourable members are aware, the Government Programme 2025-2029 has pledged to replace the Commission of Inquiry Act of 1944 with a legislation that is modern, transparent, and fit for purpose. Indeed, Madam Speaker, the Act it replaces is over 80 years old. It was shaped in a colonial era when the Governor-General, not Parliament, determined how and why inquiries would be held. It contains no procedural safeguards, no timelines, no recognition of rights, and no clarity as to the legal status of findings. Over time, it has become a blunt tool, sometimes used well, sometimes not. In a modern democracy, we need more coherent standards, less confusion. We need a sharper instrument, one capable of balancing truth-finding with fairness and legitimacy. This is why we are now replacing a bludgeon with a scalpel. The flaws of the old law are well documented. Commissions of inquiry have too often lacked credibility, not necessarily because the idea of truth-finding was wrong, but because the process failed. Our courts have thus intervened repeatedly. In the case of Ramgoolam versus Matadine 2001, the Supreme Court criticized the Commission for making serious allegations against the sitting Prime Minister without giving him a chance to respond. In Valaiden versus Matadine 2002, it found that individuals were denied the right to rebut damaging evidence heard in their absence. There have been many such examples over the years. In fact, it is now expected that after the publication of every report by a Commission of Inquiry, there will be applications for judicial review, where people affected by damaging comments would go to the court to seek justice. They would say, my rights were violated, my reputation has been damaged, I was not given the chance to rebut allegations against me, I was not treated fairly. And regularly the Supreme Court has vindicated them. In 2022, even the Privy Council found, in the case of Payendi versus Lam Shanglin, that, I quote, the procedure adopted by the Commission in relation to the appellant did not accord with the principles of fairness and natural justice, unquote. The courts have been clear. Natural justice is not optional. Fairness is not negotiable. Where rights and reputations are at stake, due process is a must. An inquiry's legitimacy depends not just on what it says it has uncovered, but how it went about to uncover it. This is not merely a philosophical point. It has practical implications. The Institute for Government in the UK has shown that public trust in the inquiry process is tightly linked to transparency, timeliness, and clarity of purpose. In their study of UK public inquiries, they note that delays, vague mandates, and political interference have all undermined effectiveness. Similarly, in Australia, the Institute of Public Administration reported that inquiries fail when they become vehicles for blame rather than instruments of institutional learning. New Zealand's Law Commission also warned of the dangers of inquiry structures that lack coherence. In its 2008 review, it noted there was no consistent approach in the establishment, management, or conduct of inquiries at the time. It recommended greater codification, better rights, protections, and clearer rules of procedure, many of which mirror the features of the bill now before this House. Dr. Scott Prasser, a leading academic in the field, has written extensively on the need to avoid inquiry inflation, where an ad hoc inquiries proliferate without consistency, leading to public fatigue and institutional confusion. He stresses that inquiries should be exceptional events, not routine political reflexes. This bill embodies that ethos by placing structure and procedure where there was once opacity and confusion. Madam Speaker, at the core of this bill lie three essential objectives: to enhance transparency, ensure procedural fairness, and strengthen the legal foundations of public inquiries in Mauritius. First, the bill enhances transparency and accountability by mandating that inquiries be held in public unless justified exceptions apply, and by requiring that final reports be published and tabled in the National Assembly. It ensures that the public is kept informed of matters of significant national concern. This will foster trust in the process and confidence in the institutions involved. Second, the bill safeguards procedural fairness. It provides a structured, rights-respecting framework for how inquiries are to be conducted. Individuals whose rights or reputations may be affected are explicitly granted the right to be heard, to present their version of events, and to respond to allegations. Third, the bill consolidates and clarifies the legal framework governing inquiries. It codifies the powers, responsibilities, and limitations of boards of inquiries, of the boards of inquiry. This removes ambiguity, reduces the risk of politicization or procedural error, and provides a clear roadmap for all actors involved, from the appointing authority to those summoned to appear. In so doing, it modernizes our public law architecture in a way that is aligned with modern democracies. Madam Speaker, let me now turn to the main features of the bill which are designed to achieve these objectives. Under Clause 3, the Prime Minister may establish a board of inquiry where he considers that a particular event has caused or may cause public concern, or that there is significant public concern that such an event has occurred. This ensures inquiries are initiated where there is a genuine need for institutional scrutiny, grounded in the public interest. This approach is consistent with international models. In the United Kingdom, inquiries under the Inquiries Act of 2005 are set up by a Minister of the Crown. In Australia, similar discretion is vested in the executive. The principle is the same. Inquiries are initiated by elected leaders who are accountable to Parliament and to the electorate for their decisions. What matters is not just the identity of the initiator, but the framework of transparency and oversight that surrounds that prerogative. In our case, this is addressed through Clause 6, which requires the Prime Minister to notify the National Assembly once a board has been or will be set up. Clause 21 provides that the Board of Inquiry must submit its report to the Prime Minister upon completion of its work, and Clause 22 then mandates that the report be tabled before the National Assembly and published within 30 days. This avoids the common problem of reports being shelved or selectively disclosed, and reinforces the duty of accountability to Parliament. The imposition of a deadline to submit a report in Clause 5 will be an important break from the past. No longer will reports be left dans les tiroirs de qui que ce soit. Clause 4 requires that every board of inquiry operate under clear, defined terms of reference. These will set out the subject matter, scope, and timeline for the inquiry to further strengthen independence and clarity. Clause 8 provides that the Prime Minister must consult the appointed chairperson before finalizing the terms of reference. This consultation ensures that the person responsible for managing the inquiry has the opportunity to shape its mandate and is not merely handed a political script that he must follow. Subject to exceptions for confidentiality or public interest, proceedings are to be held in public. Members of the public, including the press, may access the proceedings and view the record of evidence. This not only builds legitimacy, but also guards against selective leaks, secrecy, and political misrepresentation. As we have seen, a central weakness of the 1944 Act was its silence on individual rights. Clause 18 corrects this. Any person who reasonably believes that their reputation may be adversely affected by the inquiry is entitled to be heard and to give evidence in rebuttal. This codification, Madam Speaker, this codification of natural justice is one of the most critical features of this bill. It mirrors the so-called Maxwellization process in UK law and directly addresses the recurring procedural failings that led to so many court decisions. Clause 5 draws an important line. A board of inquiry may not make a binding determination on civil or criminal liability. It is not a court of law. It does not pronounce guilt nor impose sanction. However, Clause 5.2 rightly clarifies that the board may still draw inferences based on the evidence it has gathered and may make recommendations. That is the nature of any investigative process, to form a view on the facts. This is no different from the position under the UK Inquiries Act of 2005, where inquiries are similarly prohibited from making formal legal findings, but may report on facts that point to misconduct or wrongdoing. This balance is essential, Madam Speaker. It protects individuals from judgment without trial, while allowing the state to learn, to recommend, and where necessary, to refer matters to the proper legal or disciplinary authorities. The bill preserves the right of judicial review. As per Clause 30, anyone aggrieved by the findings of an inquiry may seek redress through the courts within 21 days. This ensures that inquiry powers are subject to legal limits and that those affected have a clear procedural remedy where those limits are breached. Madam Speaker, let me be clear. Clause 32.2 provides that all pending commissions under the old law shall lapse. This will apply to the Commission of Inquiry on the affreightment of Betamax. The Betamax case has been the subject of a long and expensive litigation saga. An international arbitration tribunal, the Supreme Court, the Judicial Committee of the Privy Council have all examined the matter. And ultimately, the Privy Council found clearly that there was nothing improper about the contract. You cannot be clearer than that. Despite this, the previous government saw fit to establish a commission of inquiry into the very same matter, targeting in particular the current Prime Minister. If you want to know what is politically motivated, learn from the other side. That commission serves no real purpose. It has no legal justification. Its political agenda was clear for all to see. It was simply an exercise in retroactive blame. It cannot be allowed to carry on and to further waste public money. Madam Speaker, this bill is not about shielding anyone from scrutiny. It is about ensuring that scrutiny is meaningful, lawful, and fair. It puts an end to a model that has too often confused inquiry with prosecution, or even persecution, and replaces it with a framework built on clarity, accountability, and justice. In doing so, we uphold the values of due process, institutional integrity, and the rule of law. I therefore commend the bill to the House.
Thank you, Minister. This